Your chapter wants you to be familiar with HIPPA, or the Health Insurance Portability and Accountability Act of 1996. It was passed by Congress to promote a standardization and efficiency in the healthcare industry. It gives patients more rights and control over their health information. HIPAA is a federal law that gives provisions regarding client privacy, informed consent, and transfer of records. It encourages paper and electronic transactions to use safeguards to protect the scrutiny and confidentiality of health information. You must comply with HIPAA standards if you are a covered entity. How do you know if you're a covered entity? Answer these questions. Are you a healthcare provider? Do you transmit information electronically? Do you conduct covered transactions? If you answer yes, then you are a covered entity and must comply with HIPAA. This chapter also goes into some very detailed information about duty to warn or to protect potential victims. Bednar in 1991 maintains that counselors must exercise the ordinary skill and care of a reasonable professional in identifying clients who are likely to do physical harm, protecting third parties from those clients judged potentially dangerous, and treating those clients who are dangerous. The counselor's responsibility also includes taking very careful case histories. Document. Advise your clients on the limits of confidentiality, so they'll know when you are legally mandated to report. Keep accurate notes of threats and other client statements. Whenever I have an exceptional situation, the first thing I say to my counselors, have you documented? Don't forget to write that down. It's so important, and do it immediately. Seek consultation. Talk to your supervisor. Find out what steps must be taken, both ethically and legally, and record the steps you've taken to protect others. So when we get in trouble with malpractice suits, it's usually because we've been negligent. You won't be sued if you've taken precautions. The book defines duty to warn as those circumstances where a case law or statute requires the mental health professional to make a reasonable effort to contact the identified victim of a client's serious threats of harm, or to notify law enforcement of the threats. Now notice that it says identifiable victim. It's really important that you understand that if you don't know who the victim is, if you can't contact them because you don't know who they are, then you're not being held negligent. Duty to protect applies to situations in which the mental health professional has a legal obligation to protect an identified third party who is being threatened. It does require disclosure of confidential information to the person who's being threatened with harm. Remember that liability can happen if the counselor fails to diagnose or to predict dangerousness. You're not going to be in trouble if you really had no idea that the client was dangerous, if none of that information was disclosed to you. If, however, it has been, then you need to document, and if there's an identifiable victim, then you need to warn them. So, for example, I had a client one time whose son had been killed at work. He was working construction and he was in a bucket and it fell off the cliff. Actually, I was just doing an assessment on this man for a DUI, and he said that he believed that his son's boss was a murderer and that he murdered his son, the employer murdered his son because he was negligent in taking safety precautions. And he said that he had a gun and he wanted to kill him. And in fact, he called the guy and told the guy that You didn't know when my son was going to die, and you're not going to know when you die. Well, this was pretty concerning to me. I did find out that the employer had already contacted the police and reported it, but that would be an example where he has bought a gun, truly believes that the employer needs to die, that you might want to make a phone call and protect. That would be fail to warn potential victims of violent behavior. You can be liable if you fail to commit dangerous individuals. In other words, didn't disclose information that could help them be committed because they are dangerous, or if you prematurely discharge dangerous clients from a hospital. So this would fall into the care of physicians and mental health workers that work in psychiatric hospitals. This all came about as a result of the Tarasov case, which was a landmark case pertaining to duty to warn. It's a really good case to be familiar with. In August of 1969, Potter, who was an outpatient client at the Student Health Center on the Berkeley campus, was in counseling with a psychologist named Moore. Potter had confided in Moore that he intended to kill an unnamed woman who was later identified as Tatiana Tarasov when she returned from a trip to Brazil. Moore had determined that Potter was dangerous and should be committed to a mental health hospital for observation. So Moore, in working with Potter, believed him. He felt like that he truly meant what he said when he said he was going to kill Tarasov. So Moore later called the campus police and stated that he felt Potter was dangerous. The campus police took Potter into custody for questioning, but released him because he appeared to be rational and promised to stay away from Tarasov. Potter was never confined to a facility. Moore, still concerned, followed up his phone call with a letter requesting the assistance of the chief of campus police. Later, Moore's supervisor asked that the letter be returned and that the letter and case notes be destroyed. He also asked that no further action be taken. This was a very, very detrimental part of this case because the supervisor, it was illegal for the supervisor to destroy that information. Therefore, Tarasov and the family were never made aware of the threats. Shortly after Tarasov returned from Brazil, Potter killed her. Her parents filed suit against the Board of Regents and employees of the university for having failed to notify the intended victim of the threat. The California Supreme Court in 1976 ruled that a failure to warn an intended victim was professionally irresponsible. The court's ruling requires that counselors breach confidentiality in cases where the general welfare and safety of others is involved. Your chapter has a couple of other cases that were really interesting. You should take the time to review them. One of them was the Bradley case on page 226 of the 9th edition, and the Jablonski case on page 226. They're really fascinating. Take the time to read them. There are some interventions that can be taken to protect others. For one thing, you should reassess the client to make sure that they're still in that state of mind, or have they moved past it. Reassess them regularly. Make note if there's any medication changes that have made things worse or made things better for the client. You may need to make a referral, especially if it's outside of your scope of practice. Possibility of hospitalization to help stabilize the client. Warning potential victims, not being negligent in protecting others. Calling the police. Informing the state child protection agency if it has to do with child. Negligence lies in the practitioner's failure to warn a third party of imminent danger, not in failing to predict any violence that may be committed. Now again, this means that if you're aware, like Moore, he was so aware that Potter was going to kill Tarasov. I mean, he believed it. So he took the right steps. If you had no clue or no idea, or that your client has not even talked to you about doing something like that, and then they go do it anyway, you're not going to be held negligent because you really didn't know about it. Another question is, what happens when the counselor doesn't know who the intended victim is? What if your client has disclosed information to you but won't tell you who it is? If you called the police, what could they do if they don't know who the victim is? In order to be negligent, you really do have to have an identifiable victim. Counselors are not liable for the failure to warn when the propensity towards violence is unknown. Don't be intimidated by every impulsive threat, but do seek supervision. Guidelines for dealing with dangerous clients is always kind of scary. Your chapter addresses this by giving you some ideas on how you can deal with dangerous clients. First of all, be sure that you're familiar again with your informed consent. Have you talked to them about what you're required to disclose? You can contact legal counsel of your professional organization and talk to them about your concerns and legally what constitutes violating confidentiality based on your relationship with that particular client. Consult with professionals who are very experienced with this population. Ask them for help and guidance. Take a workshop. Become familiar with what you can do to protect yourself and other victims. Make sure that you have professional liability insurance. Generally, the duty to warn and to protect is indicated when these three conditions are present. First of all, there has to be a relationship between the client and the counselor. You're not held liable or negligent if it's not your client. There has to be a reasonable prediction of harmful conduct. In other words, the client has a history of violence, making threats that have a tangible plan, has a weapon, those sorts of things. And again, the potential victim has to be identified. Your documentation should include a brief statement of the rationale for the actions taken, your actions taken. Never alter clinical records and never destroy them. Another really stressful situation for clinicians is when they're dealing and working with suicidal clients. As part of the informed consent process, counselors must inform clients that they have an ethical and legal obligation to break confidentiality when they have a good reason to suspect suicidal behavior. When do you take these threats seriously? Counselors have been trained or should be trained or should get trained in recognizing warning signs of suicide. Take the least intrusive steps to prevent harm, but do take action. There are some guidelines for assessing suicidal behavior. Take the cry for help seriously. Take direct verbal warnings very seriously. Pay attention to see if there's been any previous suicide attempts. You should know the signs of depression, which is pretty common to all suicide victims. There's usually tests and screenings that can also help you identify depression, like the Beck test. Be alert for feelings of hopelessness and helplessness, desperate, guilt-ridden worthlessness. Explore stressors of loss or separation. Has there been a death? Has there been a breakup? Explore other severe anxiety or panic attacks. See how long that's been going on. See if your client is struggling with those. Determine if there's a plan. Is there drug or alcohol abuse going on? Are they giving away prized possessions? Do they have any psychiatric treatment in their history? Do they have a good support system? Check all of these issues out to determine suicidal behaviors.